Trial Tuesdays once again. Today, we're talking about a recent South Carolina ruling that can and probably will impact the outcome of DUI trials across the state. Attorney David Aylor, a man who doesn't just follow the letter of the law, but the entire alphabet, joins me right now to tell us about the decision having to do with those breathalyzer tests. So, Counselor, welcome back to the program. Tell me all about this. Well,
essentially what happened was there was a case out of Columbia, South Carolina. A local lawyer there, Joe McCullough, had a client who there was an issue with the breathalyzer room. And obviously people are familiar with the roadside tests when you see individuals taking different tests on the side of the road that have been alleged to be under the influence of alcohol or drugs. Secondary to that, of course, is a breathalyzer room. And in this specific case, this individual was alleged to have not blown hard enough, if you will. The breathalyzer in South Carolina is a machine that you actually blow into. There's also blood tests, but the first test they always give, of course, is the breathalyzer. And what the officer involved in the case did was encourage the person to blow harder because it was not registering within the machine.
So it wasn't giving you the reading?
Correct. And what the judge said was that that was unlawful and threw it out. And the reason it was because it was based off expert testimony that the defense lawyer brought in, saying that the results could be skewed because of the blowing harder effect, which is huge when it comes to breathalyzer because often people have issues with how hard they blow. Officers will either, one, call it a refusal, meaning that they didn't participate and didn't take it at all, or two, encourage them to blow harder, which now we know may actually affect the actual results.
So basically, people that were suspected of DUI weren't blowing hard enough to try and trick that piece of technology, because technology doesn't always work the way we want it to. This was kind of a way to skirt that, but now you're saying that that cannot be used in a court.
Well, and the issue being because if you're encouraged to blow harder, you could actually be affecting the machine and it being, you know, a result that's not actually accurate, and that's really what the case boils down to. So really the limbo question is going to be, you know, if an individual doesn't blow hard enough to register it, now that the officer's not able to encourage him or her to blow harder, is it going to be considered a refusal? Or is it going to be considered a malfunction in the machine?
So what happens in a court case right now? Obviously, you go through those field sobriety tests, and that's where an officer will get that suspicion that you may have been driving, you know, on the influence of alcohol or drugs, so they want to take you back to the station. What happens now then? Can they still use that breathalyzer as evidence in a trial against you?
Well, they're absolutely still going to use it because it isn't something that happens in every single case. But I know as prosecuting DUIs now, as well as defending them, you see it fairly often. And ultimately what the officers often do is call it a refusal if they don't get that reading. However, now if there's on tape that shows where the officers encourage someone to do it, it could be thrown out based upon this decision.
And that refusal obviously has implications for that person as well, because that refusal takes away your license right away. Is that correct?
Correct. Their license is suspended for 6 months. However, you are, of course, able to apply for an administrative hearing to try to get that license back and get a temporary license in the in-between. So it'll be interesting to see where this goes. But as far as South Carolina and DUI law, it's pretty important. And it's pretty important for anybody that's had this issue come up in a case.
Usually when these things kind of happen in a courtroom and they set a precedent, somebody go back and try and rewrite the law or try and fix that loophole. Where do you see that going?
Well, I think ultimately this will be appealed, similar to other issues related to alcohol, and what will come out from what the judges decide will be the new law, if you will, judge-made law, as opposed to the legislature. This may cause changes related to the machines they use for the breathalyzers. You really don't know at this point, but ultimately it's all about the individual who's being accused, because if in fact the officer is encouraging someone to do something that would actually could negatively affect you by taking that test, you know, that individual should be protected and their rights should be protected.
Well, I'm sure you'll be following that for us through the appeal process. Attorney David Aylor, thank you so much for your time, sir. Do appreciate it as always.
Thanks for having me.
And stay with us. Much more Low Country Live coming up after this.